Uh, For pronouncement of judgment, item number 1, production list.
Will dismiss.
Adjournment request, if any, from item number 1 to 6. From item number 7 to 17.
May it please, your lordship.
Yeah,
Item number 16 and 17,
16 and 17.
my lordships.
Yeah.
I have the consent, my lord, was pleased to direct to file an affidavit. We had the affidavit shown, we'll have it filed in the course of the day. Could it be after a few days?
Last occasion we asked.
I got the verifications done, my lord. We fall within the age bracket. On that note. The lady had come down and so on. We'll
Yeah,
file it.
you have drafted the affidavit.
Yes, yes, yes. So on also.
So what are the?
The basic thing is, according to the metric, the admit card and the certificate, she falls within the age bracket. She correctly disclosed in her affidavit in opposition, her age to be 52 as in 2016. But the denial of that 41 years was not so specific to match with the age bracket. She's correct on the age. This August she'll be retiring. That's on stand. We'll have it on record. We sought the consent.
After summer vacation, is yes,
Obliged, lordship.
after summer vacation.
Item number 18 to 29.
Before the lordship, I may be permitted to withdraw item number 27, my lord.
Withdraw.
Yes, my lord.
Wants to withdraw the repetition dismissed as withdrawn. Anybody from the other side?
Sir, I'm for the income tax department, doctor.
Income tax department. Okay, mark the presence of that.
May I please your lordship, with the consent of the address, I beg to mention item number 29 of the
Item
daily list, 29 lordship. I have already circulated the adjournment slip, lordship. We need some time to file our affidavit in opposition, lordship, in this matter.
Adjourn at the request of so and so.
Deeply obliged.
Yeah, please, Lordship. Lordship, I beg to mention item number 28 by taking consent from the other side. Lordship, my senior is out of station.
Adjourn.
Item number?
28.
Obliged. Yes, Lordship,
28.
28. Obliged.
From item number 30 to 36.
Lordship, item number 30, can it be after which, lordship?
30.
30, lordship.
Summer vacation, all the taxes will go to after summer vacation, whatever the adjournment. Yes.
Obliged.
My lord, with the consent of others, I beg to mention item number 34. Let it come next week, my lord, any day.
Hearing matter, then it will go after summer vacation.
The interim orders shall continue.
Interim order limited,
Till the next.
check it, if limited. then
Yes.
Extend it till next day. Yes.
Any other request? Orders, item 1.
The case came up on the Lozima court on Friday. This case. So, and then the respondents number 8 and 9 were.
No, which item number?
It's a
Which
PIL 53.
No.
Item one.
I'm sorry.
देखिए, taking into consideration the note of the Registrar General Guwahati High Court. This court, by the order dated 15/5/2024, directed the registry to issue notice to the petitioner in the writ petition number 4472/2020, so that she may, so that the petitioner may move appropriate application for refunding the amount of rupees 50,000 which has been deposited by the petitioner pursuant to the direction given by this court on 20/10/2020. Full stop. This court has also noticed that the writ petition filed by the petitioner challenging the e-auction notice issued by the respondent bank has been dismissed, while the order dated 3/8/2021 has been infectious. Full stop. Para. Pursuant to the direction given by this court on 15/5, the notices issued to the petitioner returned unserved with the report that no person is residing on the given address. The petitioner is not residing on the given address. No person by the name. No person by the name of petitioner is residing at the given address in the, at the address mentioned in the writ petition. Full stop. In such circumstances, we direct the Registrar General Guwahati High Court to deposit the said amount of rupees 50,000 with the Guwahati High Court Legal Services Authority. In these observations, these proceedings are closed.
Guwahati High Court Legal Service Committee.
Committee.
Item 2.
May I please, your lordships?
Yes.
Your lordship, this is a PIL pertaining to supply of drinking water in Guwahati. May I draw your lordship's attention to last two orders, 27th of March and 8th of April.
Yes.
Your lordships had asked them to apprise the honorable court.
Yes. You have
No,
not
not
filed
to-
any affidavit.
Lordship had directed me to give the status of that particular project of the AUIIP, my lord. Lordship will ignore the first address, my lord, the contents, my lord. First page is over, second page.
Substantial work is yet to start, my lord.
Yes, yes.
Phase 1 is just a misnomer.
Just a-
There's no work.
Just a minute, just
Yes.
a minute, Mr. Concept, please, just a. What is this pre-loan appraisal? Appraisal,
Financial bank.
pre-loan appraisal.
My lord.
In the
First of
last
all,
line,
my lord, on September 2024, Asian Development, New Development Bank official has come here.
yeah,
They have negotiated it.
Yeah.
Now the tenders have been floated, the consultant will be appointed. Then they will come before the date on July, next month, they will come for pre-appraisal. After the pre-appraisal, everything, if they are satisfied, everything has been done as per their requirement, then the loan will come. They will verify whether it has been done as per their requirement.
is there any expected date when they are coming?
July 2024, next month they are coming.
one thing, you file an.
Lordship, I'll file an affidavit.
Yes, Mr.
My lord, I just wanted to draw your lordship's attention to two things. Now, from 2021, this particular phase of the project has been without any funds, my lord. So this is the work, the progress seen by in this phase is the worst, my lord. So for your lordships had in fact on 27th of March 2024 had recorded that on that particular day, 27th March itself, there was a meeting which was supposed to take place with the new development bank. If your lordship may kindly have that order of 27th March 24,
Yeah,
where the statement is recorded that the detailed project report for phase 2 of Southeast Guwahati water supply has been approved by the Ministry of Housing and Urban Affairs, and the meeting is being held with the representatives of New Development Bank today, that is on 27th March 24, for obtaining loan for completion of phase 2 for Southeast Guwahati. Recording the submission made by the Learned Standing Council lists the matter on 8th April 24 to enable him to apprise this court with regard to the outcome of the meeting held with the representative of the New Development Bank. Lord, as I could understand from the statement of my learned friend, which I mean I haven't seen the affidavit yet, but the funds are yet to be sanctioned. Lord, this is a
Yes.
very serious.
funds are yet to be sanctioned. They have visited this new development bank team has visited and fact-finding mission in September 2023, and now they'll is about to conduct the pre-loan appraisal in July 2024. Since it's a externally aided project, so they are required to get the loans, and this new development after considering the feasibility or whatever it may be, they'll sanction the loan.
My lord, all that I would like to point out at this stage is that let the process be expedited, because since 2021 there has been no
But
contractor.
ultimately, somebody has to provide the fund.
Of course, my lord, of course, I completely bow down to that. All that I'm
So
pointing out.
they are working on it.
No, my
They
lord,
are
from
working on it.
21,
Yes, it's a-
2021.
The project is delayed, but they are working on it. So at present, what direction can be issued to them?
Let it be expedited is all that I'm praying for, my lord, today.
Certainly, it will take some time. We are granting them time to give an affidavit of this effect that by loan negotiation with the NDP in December 2000, we'll see to it.
May I also draw your lordship's attention to two more orders, if your lordship permits me.
Council appearing for the
My GMC, GMD and
urban, Assam Urban Infrastructure Investment Program has submitted a progress report dated 7/6/2024, detailing out the implementation, detailing
Timeline.
the timeline for implementation of the phase second,
For the southeast.
phase second of the Southeast Guwahati Water Supply Project, full stop. The net council is directed to file an affidavit in this regard within a period of 2 weeks. Within a period of 2 weeks, list after.
May I, my lord, may I just point out one more order, if your lordship permits me?
Yes,
My lord, may I kindly have the 17th January 2023 order, my lord, once.
yes,
I'll just point out again, my lord, a statement that was recorded. This is, my lord, at the, effectively, it's the 4th paragraph of the order, my lord.
yes.
Refuting such arguments, so and so submits that the work for making potable drinking water available to the Guwahati city dwellers is progressing on a war footing, and that the department reasonably expects to make potable drinking water available to every household by the end of March 2024, my lord. We are in June, my lord. I thought I'll at least draw your lordship's attention to this order, my lord.
Yeah, that's right. But ultimately, if the funds are not available, we have to.
That is for one phase. That is only for
consider
Southeast.
it.
That is only for Southeast. Rest of the phases is also they should give some indication to the Honorable Court, my lord, as to what state the phases are in.
Let them complete this first phase or phase second, then we'll consider it, sir. Ultimately, if the funds are to be provided by some external agency, then it has to be fixed sometime. Let's start 2 weeks.
Obliged.
Item 3,
Please, sure. Yes. Well, we have filed the additional affidavit, rather the reply, But perhaps my learned friend was saying that he has not got the copy. It was served on the government advocate.
My lord, we haven't received, the copy actually. We haven't, the standing counsel.
Okay, and in consequence, the
I'll
petitioner
give it
submitted that additional affidavit is, has been filed by them.
Affidavit reply, sorry. Affidavit in opposition, sorry, reply.
Affidavit in,
Reply.
opposition to the reply is filed on behalf of them. Full stop. Learned counsel appearing for the respondents, place some time to peruse the same. List after, list after summarization.
Item 4.
Yeah, please, Lordship. Lordship, here we will file affidavit in reply.
Last time also,
May kindly grant 2 weeks' time.
last time the time was granted
Yes, Lordship.
on 20th of May,
Yes,
almost 20 days.
yes, Lordship.
Yes,
Lordship, may kindly grant 2 weeks' time more.
one more opportunity is granted to the concept of the petitioner to file counter to the reply filed on behalf of the respondent number 124, list after summarization.
Obliged.
Item 5.
May I please? As per office note dated 6/6/2024, my lord,
Yes,
Sir,
1,
sir,
2, 3 and 8.
sir, this will be awaited, my lord.
I have. I have
The new
entered,
style.
My lord?
This is the new style of tying the.
No, my lord, sorry. Sorry, my lord.
I have entered my appearance on behalf of the respondent number 2. 2 weeks time.
Respondent number 1, 2, 3 and 8.
8, my lord.
They have not been served and the
I am
respondent
for
number 2 is, he is appearing. What about the others?
Other service will be awaited, my lord.
Okay.
I may be allowed to
To the
take
office
trace
report.
step, my lord.
Notices issued to the respondent number 1, 2, 3 and 8 has not been received till date. Full stop. Then it's, Mr. So and so put an appearance on behalf of the respondent number 2. Let notices of the respondent number 1, 3 and 8 be awaited for 3 more weeks.
Item 6.
It means your Lordship. Lordship, my senior Mr. SCK also, he's out of station.
4 days delay, IA application, you can very well argue it.
Yes, my lord.
4 days, the point in. Six. We got it. As per the Lauzima code. As per the report from the registry dated 6/6/2024. The notice of the application upon the sole respondent is duly served. Full stop. No one has put in appearance on behalf of the respondent number 1. The matter comes upon for consideration of the IA number so and so with a prayer to condone the delay of 4 days in filing the connected appeal. In filing the connected reference, custom reference, full stop. Having heard the learned concept of the applicant and after going through the contents of the application, we deem it appropriate to condone the delay of 4 days in filing the custom connected custom reference. What it is registered.
Filing number
It is already registered.
1364 is filing number.
It's filing number. Connected custom reference. Full stop. The registry is directed to register the same and place it before this court of customer.
Ashok.
Item 7.
Please, Lord.
Lordship, there is a IA in the writ appeal connected and it appears that there is a delay of 584 days. So Lordship will file an affidavit in opposition, so 1 week may be granted to us.
You are appealing for all the respondents?
I am appearing on behalf of all the private respondents.
Okay, Mr. So-and-so put in appearance on behalf of, all the private respondents. Please some time to file counter to the IA number so-and-so. Time date for is granted. Let's start for summer vacation.
Lordship, petitioner may be granted directly to furnish the copy of the IA.
You are not
for
in
the hard
talking terms with them.
No, I have already.
You are
No,
not in talking terms with them.
hard copy is not.
Ask him, he'll give, provide you.
Okay.
Yes.
Item 8.
May I please a case? Small compilation of judgment on the writ of certiorari. Broadly, my lords, what fell from my lords, that the certiorari and mandamus, my lord. This is that case, my lord.
Yes,
My lords, what fell from my lords that mandamus, the mandamus is an adjunct to the certiorari jurisdiction. That your lordship would find at page 84 of the compilation. Generally, it is a supervisory, my lords, jurisdiction. If this is what my lord was looking at, para 15, on facts, though they didn't, they interfered with the
page.
my lords, page 84, para 15, the judgment starts at page 75. This is only, my lords, in response to what fell from my lord Justice Shah, my lord. My lord has para 15.
Yeah.
May I read? It is true that sometimes it is prudent to couple a writ of certiorari with a writ of mandamus to control the exercise of discretionary power. The following illuminating passage from Dismissed Judicial Review of Administrative Action, 4th edition at so-and-so, prettily sum up the function of writ of mandamus. And if my lords can come straight to Professor H.W.R. in the following page, my lords. This is what my lord fell from my lord. The next page, Professor, in the middle of the next page, my lord. Professor H.W.R. Wade in his Administrative Law, 5th edition, at page 638, also defines the purpose of writ of mandamus in these words. Mandamus is often used as an adjunct to certiorari if a tribunal acts in a manner where it has no power to act at all. Certiorari will quash the decision and prohibition will prevent further unlawful proceedings. If there is a power to act, but the power is abused, as by breach of natural justice or error on the face of the record, certiorari will quash and mandamus may issue simultaneously to require proper rehearing. An example of Board of Education versus Wright cited elsewhere. The board's decision was ultra vires since they had addressed their minds to the wrong question. Consequently, it was quashed by certiorari and board was commanded by a mandamus to determine the matter according to law within the limits indicated by the House of Lords. My lords, if your lordship sees the serial number 2, this is a constitutional bench judgment. It starts at page 14, but the relevant part at 22.
No, Mr. Goswami, why don't you give us what is the sum and substance of your argument? Can
No,
you-
Sarman, this is my lord. Your lordship wanted us to look
No, we'll
into the
come to
law of
that.
certiorari.
Come to that.
Huh.
We may not remember what is.
I'll tell your lordship, my lord, your lordship, this is a case, my lord, on facts, my lords. An appointment took place pursuant to a selection process of 2 posts of junior assistant. That was impugned by the unsuccessful participant in the selection process.
Now, after 9 years, the High Court has interfered with the selection and appointment on the ground that 4 irregularities, illegalities were found in the selection process.
The petitioner has approached with the delay or the matter
Court.
was pending therefore
I have, my lord, the petitioner approached on time,
Within time.
within, I can't say that, but therefore, a recent judgment of my lord Supreme Court, where the court has said that writ of certiorari cannot be issued as a matter of course, and it must be tempered with equitable consideration. That your lordship's, my lord, the recent judgment, therefore,
consideration depends upon the facts and
and that is not true, absolutely. One aspect is 9 years of service. I'm not saying that the writ petitioner was at fault in approaching, it's not a delayed him. But the fact of the matter today is that 9 years have passed by. And the High Court also, my lords, the learned single judge says that after setting aside, it is open to the authorities
to grant them
do a
age rejection.
weightage and condemnation of. Now, the essential on facts, my lords, whether the allegations against the petitioner, my lords, really pertain to the written examination portion of it. My lords. So far as the Viva and the computer typing, actually the writ petitioners benefited. Though High Court has gone, my lord, the learned single judge has gone on all aspects, my lord. So far as the written exam is concerned, the first thing against me is that the authority, because my father was an employee of the employer. So at page 140, my lord, if your lordship see, 2 gazetted officers were authorized to collect the question paper from the question setter in sealed cover. If your lordship just have a look at page 140 of the writ appeal. That is, the High Court at page 32 says that creates a doubt because he has got high marks in written examination.
In comparison to all the
In the other, the interview and viva. Now, the second thing which is put against me in the sense the written examination is, a committee was constituted on 1st of April to evaluate the answer script on 7th of April of 2015. Now, while recording the minutes of meetings, one of the members, signatory, wrote the date 30/3/2015. So what is put against the written examination is perhaps the members of the selection committee evaluated the answer script prior to the notified date. So essentially, my lords, these are the 2 points. So,
third point is also there.
my lord,
The committee, constitution of the committee, and out of which only 2 persons
But
have
that-
signed the
I'm
manuals.
coming to that. That
And one of the person has even said that I was not member of
my lord, I'm coming to that. That is in the computer typing. That is not in the written. Written is restricted to only these 2 points, my lord. In the, my lord, I'll show your lordship. There, my lords, there I'm saying, that is why I'm saying those are benefits in favor of the computer typing and Viva. Actually, the other 2 candidates got substantially higher than me. So, my lords, that's the argument, my lord.
Yes,
My lord, if your lordship comes to page 85, that where the two signature thing, that pertains to the viva voce, man. Your lordship may have a look at page 85. My lord has page 85, the writ appeal. Minutes of meeting of committee to conduct viva voce in its sitting held on 25/6/2015 for filling up vacant post of junior assistant in the office of the general manager, district industries and commerce center. So and so members present, all five were present, my lord. The committee with members as mentioned above had conducted the viva voce test. Of the candidates appeared, the committee decided to award marks to the candidate by each member as below. Personal test 10 marks, general awareness test for 40, total 50. After completion of viva voce test, the member convener, Mr. K. Das, FMDICC Golaghat, had compiled and placed the statement of marks obtained by each candidate as below. Your lordship would see the writ appellant is number 1 who got 18.6 and the writ petitioner is item serial number 6 who got 23. And the problem is, my lord, the signature is only 2, though they were all 5 were present. But this pertains to the viva voce, where among the 3 candidates, 2 selected and the writ petitioners, I got the lowest.
But the question of that.
I quite see my help.
In which stage of the examination, which person was benefited? In fact, the question is, if we look into whole scenario, then certainly it's this whole selection is.
Your lordship is right. What the learned single judge says, there is irregularity in each stage of the selection process. But what I'm trying to say, convey, my lords, is that if the selection committee had a motivated design to benefit the writ petitioner alone, then, my lords, he would have been awarded marks, higher marks, both in the viva and the, my lord, I am only making these arguments because now, my lord, your lordship would see the equitable consideration. Because what is held against me is really pertaining to the written test. Written test, my lord.
Not only written test in the whole scenario, if there was some irregularity or leading mistakes, each part of the stage of the selection.
If your lordship sees at 85,
no, my lord, selection itself was
at 85, what has happened? The minutes records that all 5 were present, but only 2 sign it. And so far as the computer typing is concerned, my lord, that at 84, here, minutes of meeting for conducting computer typing held on 11/6/2015 for the post of junior assistant in the office of so-and-so. Members present, 3, 3 are named. And your lordship would find at page 144, the committee included another 4th person at 144. He was absent. If your lordship sees at page 144, for computer typing, there were 4 members. Serial number Sri Somadhar Gam, he was absent at page 84. But the 3 out of 4, my lords, were present. And here also, if your lordship sees at 84, the writ petitioner got 36, I got 16.
Yes.
This Mr. Gam was also member of the selection committee. So when the final selection committee meeting minutes are recorded at 97, my lords, page 97. And if your lordship sees at 98, it has his signature, but subsequently he says in pursuant to an RTI, but it has its signature. I am saying, my lords, we take that one member was not, will that vitiate the committee proceeding?
Why not?
No, the court, Supreme Court has
Mr.
held,
Goswami,
my lord.
you see, it is not one particular
I
issue,
quite agree.
which is, now the learned single judge has found
Three,
three
four.
areas where things were not in order. The problem is, as you know, all these REIT proceedings are actually public law remedy.
Right.
The element of public interest is always built in. If it cannot be disputed that there was serious anomaly in the recruitment.
I am
process,
trying to persuade your
a
lordship.
different thing. Then having the element of public interest involved in a matter. Can the REIT court ignore all these things,
No,
reverse a finding merely on the ground that
No,
be
the
hard
court
on
has
the-
chosen to exercise its tertiary jurisdiction to quash it. So whether, my lords, I am just my lord, whether the facts of this case, most importantly I am trying to persuade the passage of time, that is, my lords, the equitable consideration.
The thing which is in your favor. The passage of
I quite
time,
see.
that is also not.
Not because
on
of the
account
writ
fault of
petitioner.
the petitioner.
But petitioner had participated in the proceedings, he participated in the interview process, he participated in the computer typing. He chose to not even protest. When he realized that he was unsuccessful, he then started making RTI. My lord, the principle of estoppel will also may come to the.
But how will you know when an interview is going on that there is something wrong in this? How will you?
No, if
how will-
there is absence of a member, that. My lord, what I'm trying to say, my lord, if your lordship sees the.
Now what you are addressing, the Leonard Single address this issue. And in paragraph number 18, he has replied it very
Your lordship is right, a detailed consideration, but what I am trying to persuade, so each aspect I am trying to, my lords, satisfy your lordship that the irregularity is not of such a nature that called for it. Let me, my lord, please, my lord, so far as the written test is concerned, the main point is that the father carried the question paper from the question setter to the, that is the main thing. I quite see, my lord,
Raises a serious doubt,
my lord.
coupled with the fact that you scored more marks in the written
80%,
test.
no, 80.
The only thing I can say in defense, so far as the carriage from the father, involvement of the father, if your lordship just have a look at 140.
Acha, Mr. Goswami, if we leave out the written marks, on the other two parameters, are you the
No,
candidate?
then
number
I'll
one?
be out. That I am trying to say that the committee was not, didn't have a design to benefit me. If they had, they would have awarded me higher marks both in the computer.
You're right. Committee never had a design.
No, then
But
my
the
lord,
problem happened when the written question papers were carried by the father of
quite,
the.
the only defense I can say, my lord, is that the employer directed me, and your lordship would see just 140. It was in sealed cover. The authorities on affidavit also have stated the same, and it was to be handed over on the same day.
Sir, either your father was not aware that my son is appearing in this exam or whatever it may be, whether
should have
he was
disclosed.
not aware.
You should have this.
My lord, I don't
Should
want
have
to make.
disclosed it, otherwise
Yeah, my
they
lord,
would
that
have
is
nominated
another
some
point
other
which was,
person.
which I argued before the learned single judge, the writ petitioner ought to have implemented the father. No, I am not canvassing, my lord. I am only putting, my lords, the cumulative fact situation, more particularly the passage of time.
First,
And
you address on that point. Otherwise.
I quite
everything is
see, my
against
lord.
you. You please
I
address
quite
on
see.
that.
That is, my lords, today the fact situation is. And today, my lords, the writ petitioner, what fell from your lordship in a case where after quashing, the benefit has also not gone to the writ petitioner. Therefore, my lords, your lordship wanted us to look.
No, that's what I have just mentioned, that That is one facet. But in every proceeding under Article 226 is a public
It may
law
happen,
remedy.
It may happen. I
So
quite
the
see
courts
that.
will have to look at the overall public
Your
interest
Lordship,
involved.
the balance of my lords, the fact
Correct,
circumstances, the most important fact is my.
So
lordship
if the
has
learned
correctly put-
single judge has reached a conclusion that there was foul play in the process and the father of the successful candidate had some role to play and these
the
are based
single
on,
judge puts it, there is an element of doubt. That is how the learned single judge has put it so far as the father, because he has got high, page 32, if your lordship see it. I don't want to go into it because it is a matter of whether you my lords, the test is real likelihood of bias in the mind of a reasonable man, whether that test is
no,
satisfied.
this is not bias. There is no bias here. It is a case where the facts, cumulative facts are suggesting that
That there is
there was a foul play.
illegality in the selection
Yes.
process
His father carried the question papers, he scored the highest mark
in the written.
and the father never disclosed it.
I quite see, my lord. There's nothing that I can say on that aspect, my lord. The only thing I can say is that the authorities, even in the writ proceeding, as well as the document prior to the carriage, that's why I was placing 140. It was clear that it was to be brought in seal cover, and there is no suggestion that the seal cover was broken and it was to be handed over on the same day, 20th. 140, I mean, I'm only, my lord, trying.
So after one day or same day, can be.
No,
whole,
the apprehension is that it was open, the candidate knew the question paper, that's why, that is the apprehension, my
The
lord.
highest number.
In the written, and he didn't do well in the other two segments of the selection process, therefore a doubt is
Your
cast.
suggestion that the committee, if the committee was of the view that to help you, then certainly they would have granted you the.
Your lordship is
numbers
right.
in So and so.
There has been an irregularity in all the stages of the selection process that has been noticed by the learned single judge. As your lordship puts it,
Why don't you address the court on the?
on 9 years, my lord.
Yes.
My lord. That is a matter of, my lord, admitted, my lord. The learned single judge also, if your lordship's at page 35.
What will happen is, the appellant has surpassed the age of public employment.
He would, my lord. That certain benefit the learned single judge gives, so far as age is concerned, weightage of marks.
I am only. What is their mind? Are they satisfied with the question? They can blame it that it's in the case. They did a little bit of suspicion.
Lordship, I have certain clarifications to make. Lordship, record was called for in this case, Lordship. We have, department has filed an affidavit, but the affidavit was filed long time back. All those records were not put in the affidavit. So record was called for, record was available with me. But while passing the judgment, of course, Lordship, the Honorable Singhvi Judge didn't consult the record. The record is with me. So from the record only, I'll make certain submissions here, Lordship. The first of all, Lordship, this process was started with the constitution of the selection committee. In the selection committee, 4 members were selected. All the 4 members were there while passing the final opinion recommending this candidates. All these 4 members have signed this. In between, Lordship, what has happened? 3 more committees have been constituted.
Subcommittee.
Yes, subcommittees have been constituted. One for the checking for transcripts and evaluation. Second is for computer test and typing, and third is for viva visit. Now, these committees, Lordship, they have evaluated these papers, and these tests have been taken up. And the contention is that the allegation is that one allegation is, Lordship, I'll have to admit that first allegation is that one of the candidates' father has actually carried the question papers. That is admitted fact, Lordship. That order is there in the record. That 2 persons, 2 gazetted officers have been ordered to get the question papers, and father of one of the candidate is one. That is there. But secondly, Lordship, that second allegation is that while checking the answer scripts, the evaluation committee actually evaluated the question answer scripts on a different date, and that minutes have been written or signed on
Evaluation committee has
on-
fixed the date for the evaluation of the
Correct.
question papers on
Correct.
7/4/2015,
Correct.
whereas the answers were checked on 30th of March 2015 itself,
correct. Lordship, what has
the day of the examination.
correct. Lordship, what has happened in the case is that the record says that their charts have been made. That questions papers have been checked on 7/4/2015. And 7/4/2015, a chart has been made. The chart is there on the record. The whole chart has been made for all the candidates, giving marks for written test. And this chart has been signed by all these 3 members on 7/4/2015 only. The only thing, Lordship, only discrepancy happened is that while compiling this, while minutes of the meeting was made, that one member has Lordship, maybe, I don't know, but maybe mistakenly with bona fide mistake, he has written 13/3. But other 2 persons, they haven't mentioned about the signature. But Lordship, one thing is correct, Lordship, is that the committee was constituted and committee was supposed to check on 7/4/2015 only. And they have evaluated on 7/4/2015 only. But while compiling this and making a chart in the minutes of the meeting, one person has signed as 33. That was the discrepancy. That is admitted fact, Lordship. But otherwise, chart is there.
That is the
That is an admitted fact, Lordship. Whether it has been done in a bona fide mistake or not,
or actually the question papers were checked on 30th of March.
that may not
is
be
clear.
that may not be possible because the constitution of the committee is later on.
That's the.
Because
that's
Lordship may
clear
kindly
doubt in
see.
the mind of the court.
No, Lordship may kindly see the constitution of committee for checking the answer script was constituted on 1/4/2015.
That's not the day when the constitution, the committee was not even constituted. Prior to that, the copies were checked.
But answer scripts, Lordship, that compilation of the chart says 7/4/2015. So that is there on the record.
It was some mistake. उसको preparation करते हुए कहीं ना कहीं गलती होगी. What you have done?
One signature, Lordship, one signature discrepancy that is there, that is admitted, Lordship. Otherwise, it was checked on 7/4/2015 only. And secondly, Lordship, as far as Lordship, there's computer test and typing is concerned, Lordship, the committee was constituted and all the persons except one person hasn't signed. 4 persons committee was constituted. That person was not there at the particular date. So 3 persons signature is there in the minutes of the meeting and it was properly done, Lordship. All 3 people were there. Then, Lordship, as far as viva voce is concerned, Lordship, it's very vital to this thing, Lordship. Viva voce, Lordship, what has happened? The 5 members were there. The individual members have given their marks in separate sheets. And all these separate sheets have been signed by all these 5 members. The only thing, Lordship, that while compiling it, the general manager and functional manager has signed there. Other 3 persons haven't signed. But these sheets were there.
That's correct.
But can you take this one person? Because determining the Page 19. Yeah. Then I would have accepted. But most important part, the computer, whatever is highest not me. So it was with two members working. These are all internal committee. No, that's correct. They have some, it is a stream paper given to him and then he is carried in very. Then it will be. See.
In totality of marks,
My lords,
what is the rank of the writ petitioner?
two,
He
my lords.
he is number two.
The other person whose selection was also set aside, Aditi Bora, my lord, he was number one. That your lordship will find at 97,
She was
96.
number one.
The writ appellant
Yes.
before your lordship was number two, the respondent number 5, no? Before-
Adit Bora, he was number one.
number 1.
He was number one.
My lord.
And this.
That and this.
Writ petitioner,
Read petitioner was number three.
number three.
Number
97 has that, my lord, compilation of 98 will, lordship will find.
No, no, please repeat the person in serial number 1.
My lord, your lordship may come to page 98 that has the
The
cumulative.
final
mark.
recommendation, what that
That's
is.
Correct, but tell us what has happened to the number 1 rank?
That has also been set aside.
Set
because
aside
the
by,
by the learned single judge.
for what reason?
For the same, because there is the whole selection process is fraught with illegality. Therefore, the whole selection has been set aside.
But was the father of the number 1 also person who carried the?
Was not
No,
a,
no.
what?
No, he.
He was not a party
In
to
fact,
the writ
in fact,
proceeding.
there was no allegation against him.
Then he has not preferred any appeal.
He has preferred an appeal, let's see, it looks like it will be listed in a couple of days.
Oh.
Yeah, I have got a copy. Let's see.
She was respondent number 5,
My lord.
Yes, earlier.
and
Before-
she appeared before the learned.
No,
single-
Learned since he was, yes, he represented.
Affidavit was filed also. The father angle doesn't pertain to her.
But
The father angle, absent the father, because the learned single judge has
Okay,
entirely
when
the,
this- When that appeal is going to be listed?
Lordship, that copy has been served to me on only on yesterday. So maybe in couple of days, that matter may be.
Is it registered?
Do you have a final number?
No, they have given, served me a copy, then they'll file it, Lordship. So they may have filed it, Lordship. I've got a copy yesterday only.
You get it confirmed. Sometime you just let us know,
Lordship.
whether that appeal is filed or not.
file for it, message for. And then it's kind of trying to find out now. So, name was that.
What's the name of the number 1?
Adit Bora, my lords, in the writ petition, which starts at
5.
38. was- If your lordship comes to 43, R5 now, already filed number. Naam please, Adit Bora. Ajit Bora. Adit Bora.
Adit.
Oh. Code of service.
We have to recommend finding that he's established that.
अच्छा ऑनलाइन कोई को फॉर
other candidates. उसकी बात वहां पर was a fourth party reporting. But I think only if you let the. As we know, I am not reported in report. ये हुआ है इसके साथ ये
Calling number.
Fine, he said, we like that.
and yes, this is a stuff. I think this is very question that we think of. And we
So I'm told, my lords, the writ appeal has been filed, but the number, they are trying to get the number.
Today it is fine,
It is filed for yes.
today.
Doctor, is just pending with filing number.
Okay, you check it up and let us know after some time.
give the number.
Then we'll decide, yes.
Item number 9.
Filing number,
676.
writ appeal number 6576 of
24.
2024, my lord.
This filing number, na?
My-
Filed on 17th.
It was 76. Filing number is writ appeal stroke 6576 stroke 2024.
Give it in writing.
My lord, we'll give it to my,
This along with.
deeply obliged, my lord, deeply.
Item 9.
Another appeal arising out of the same judgment has been dismissed by your lordship.
Yeah, already.
Regarding the validity of this allegation, my lord, I am not on that, my lord. I'm here today, my lord.
Yeah,
My lord, my second grounds for appeal is, my lord, that the respondent number for here. They are saying that out of 14, they have selected 11 candidates. Among the 11 candidates, they have selected 3 OBC category. Among the 3 OBC category, here one candidate is not belongs to the OBC category. Accordingly, I have filed the RTI. In my RTI reply, my lord, they are saying that is page number 51. And thereafter, they have directed the 3 OBC candidates to produce the OBC certificate. Among the 3, 2 has produced
the
the OBC
question
certificate,
is
my lord.
this, that the select list is already expired.
Expire, my
How
lord.
can
Yes, my
we
lord.
grant you the relief?
My lord. But
That is what the learned single judge has said.
yes, my lord.
And why this impugned order, 2 writ petitions were decided,
My lord.
out of which one appeal we have already dismissed. So we are bound by that, sir.
Yes, my lord. But they in the order dated, my lord, the passed by the learned single judge, my lord.
Yes,
There is also a paragraph number 2, third line. It is also observed.
yes.
In third line, my lord, page number 70, my lord, Candice, my lord.
Yes,
In WPC number 89/2022, a further allegation has been made on the candidature of the respondent number 4 by stating that he does not have the requisite documents towards his claim to be an OBC candidate, my lord. But
that's
on
right,
that
but,
regard,
but
my,
please kindly consider, the learned single judge has said that since the select list has already expired, no relief can be granted to you.
my,
That is there,
my,
and you approach the court
in-
after the expiry of the select list.
my lord.
That's
That
why
is-
only,
that is true, my lord. My
that
only
is true,
addition,
then matter ends there, sir.
my lord, only direct the respondent authority, my lord, to verify the matter and thereafter, if he can produce the OBC certificate, my lord, then I have no objection, my lord. Then if he is not belongs to the OBC certificate, OBC category, my lord, how he can be appointed? Because that OBC quota is gone from our hands, my lord.
Writ petition is filed by the writ appeal is filed by the petitioner, even with the order dated 1584. 2024 passed in writ appeal number 18, writ petition number 89 oblique 2022. Full stop. It is noticed that by the impugned order dated 1/5/2024, the learned single judge has decided two writ petitions, that is writ petition number 89 oblique 2022 and writ petition number 5484 2023. Full stop. This court wide order dated 5/6/2024 has already dismissed the writ appeal filed by the appellant in writ appeal number
183.
writ appeal filed by the appellant in writ petition number
183/24.
writ petition number
5484.
5484 oblique 2023. Hence, in view of the above, this writ appeal is also dismissed.
Obliged.
Item 10.
My lord. My lord, we were informed that he has some difficulty. Mr. Cal, my lord.
Tell, yes, today shall is not.
He has some difficulty. It can be, lordship can have it on Wednesday, my lord, because there is some urgency. Otherwise, they might give the work order also in the meantime. Huh? On Wednesday, if they don't turn up, then we'll press our case.
Next week,
Lords.
next week.
No, my lord.
We have some difficulty.
In that case, my lord, status quo is on today, my lord.
Then Thursday.
He's well allowed. 13.
Item 11.
लेकिन trying to get it.
Yes.
May it please the lordship. This PIL is filed for against the lordship misappropriation of government fund lordship in PhD department while implementing lordship National Rural Drinking Water Program lordship in Jorhat district lordship. It was aimed to provide 6 Gaon Panchayat and 33 village lordship. It was started in 2014-15, but lordship till date only one Gaon Panchayat and only 7 villages
This
has
issue
provided.
was raised in some other PIL also.
Lordship, that is different lordship. That is
Shivsagar, that is Shivsagar.
Sagar lordship. It is Jorhat district lordship. And in this regard, lordship, kindly come to page number lordship 50 lordship.
50, yeah.
Lordship, the Superintendent of Police, Directorate of Vigilance, Anti-Corruption, Assam Lordship has also directed the Superintendent of Police Jorhat to inquiry the matter and take necessary action in this regard, Lordship. Till that,
Yes, ma'am.
Lordship, at the moment, notice may be issued. I have to take instructions.
You are appearing on behalf of whom?
PH department.
What about this home department? This home department is party.
Yes, my friend. Judgment which
Yes,
One,
Lordship.
2, 4, and 5, my lord, I am repeating.
You're appearing for 1, 2, 4, and 5. And you're appearing for
I'm appearing for 3 and 6, Your Lordship.
3 and 6. Issue notice. The so and so put in appearance on behalf of the 1, 2, 4, and 5. So and so is appearing on behalf of the respondent number 3 and 6. Then the respondents may file their response to the writ petition within a period of PIL petition within a period of 6 weeks. Up to 6 weeks.
Obliged, my lords.
Item 12.
May, may it please your lordship. My lord, in this appeal, my lord, the appellant who was appointed as sub-inspector of police way back in 2009. My lord, he was transferred on 2012. And after that, my lord, he did not join. And then, my lord, he joined on 9/10/2018 after giving shockers notice by the authority. Now, he explained the position, my lord, why he could not be present because he was suffering, then his wife was also suffering, his father expired.
For 6
Then-
years. For 6, 7 years.
My lord, that's a very tough question, my lord. I'm quite aware. Now, my lord, the explanation,
Yeah.
my lord, then ultimately well, the department was not satisfied with the explanation, quite obviously. And after that, my lord, inquiry was held, then he was dismissed from the service. My lord, shockers notice was given, which your lordship will find at page 79,
79.
my lord, that is. Your lordship will find at page 79, has your lordship got that?
Yes.
Now, with reference to the subject cited above, you are hereby asked to submit your reply why major punishment should not be inflicted upon you for being absent from duty. Now, my lord, the department has already framed their mind that major penalty will be imposed. For that limited purpose, I have come only, my lord. If your lordship is satisfied, my lord, your lordship may issue a notice. The rest is up to your lordship.
Will pass the.
Obliged.
Item 13.
Dismissal.
Hello. This is the appeal prepared against the order passed by the Honorable Single Judge. The Honorable Single Judge did not consider the facts that as many as 4 inquiry has been conducted against 4 persons and the similar matters on similar charges has been leveled against all the persons. But instead of making a common inquiry, my lord, separate inquiry has been conducted. Even the conducted inquiry conducted against other 3 persons. I was not made as witness also. I am not witness. They were
What are the charges?
charges, my lord. They alleged that I misappropriated money by using 3 checks.
It was the person in
My lord?
whose bank account the money was
Yes,
transferred.
yes.
Yes.
Your lordship kindly see the page charge, focus, my lord. Page 31, article of charges.
31.
Yes, my lord.
Yes.
The charge number one, my lord. There's a 90,000 I have been in case. And charge number two, 96,000.
By some money
Yes,
was deposited in your bank account
yes.
and it was remained with you for a year. This is what the main allegation, 5 lakhs, some odd amount was there.
Yes.
You were the cashier there.
No, I am, yes, I am, clerk, clerk come cashier.
Come cashier.
But if you also kindly see the check, who are written the check, those were not examined.
Money was in your bank
But,
account.
but because my lord, you lost kindly, I point out page 241, my lord, 214 you lost kindly seen. Those check also they showed.
Admit, issue notice.
Hello.
I appear and take notice for the respondent bank.
All the respondents.
Yes, I already have copy.
Admit, Mr. So-and-so put in appearance on behalf of all the respondents. Hence, no formal notices we issued to the respondents. This for the hearing in due course.
My lord, in the end I will be returned. It will be hearing after 4 weeks, my lord.
Or you
Because
want an order, we'll dictate order just now.
My lord.
Yes.
Hello, listen.
Item 14.
Made three your lordship. Hello, in pursuance to the order dated 19/4/2024.
Yeah.
The forest department have to apply the code, my lord, regarding, my lord, no, a working plan of the forest department.
Yes.
Forest department by the most.
22 forest reasons.
Lordship, here there is this one thing which I wanted to place it for your lordship. After these suo motu proceedings were initiated in April of last year, in June, the new National Working Plan Code of 2023 has come into force. So I inquired with the officers that is why your lordship, all the plans have to be redone, your lordship. But be that as it may, there is a timeline fixed as per this code, your lordship. And my specific instructions are that we are committed to meeting the timeline fixed under the new code.
What are those timelines? What are those timelines?
What they have stated, your lordship, on instructions is that for the working plans outside the 6 schedule areas, your lordship, there by the end of 2024, and
Good judgment.
in the working plans in the 3/6 schedule areas, your lordship, by the end of 2025. I may be permitted to file a short affidavit, your lordship. I'll bring everything on record.
Okay, yeah. Then this concept, Mr. So-and-so appearing on behalf of the forest raise 2 weeks time to apprise this court regarding the implementation of the plan in respect of remaining forest divisions. Stop. Just after summer vacation.
Deeply. Deeply.
Item 15.
The matter pertain to victim compensation scheme which is pending since 2015. Lordship, can you see last order at 5/4/2024?
Money they have to provide now.
Now they are coming with a proposal, the liability.
But we have filed a fresh affidavit bringing on record the quantum which is required by the Assam State Legal Service Authority, which is to the tune of 44 crores odd. And I'm told that they have now sent a proposal for 9 crores only.
Only.
So that's all, you know.
By the
That's what
state?
I have got on record by way of my additional affidavit. I have
By
got-
the state.
By the state. I will also
Yes,
find
who
that
is appearing for the state?
finance was supposed to.
Finance and Home Department, my lord, I think.
It is not the lordship, there was a meeting pursuant to lordship's order.
Is a demand of 44 crores, you are contemplating to sanction only 9 crores.
No, no, lordship, 9 crores has already been allotted. Regarding that, lordship, we have,
That you have already allotted.
Yes.
But what about the remaining?
pursuant to that, we have already had a meeting with the Home and Political Department, lordship, where we have asked them to send a proposal regarding the utilization of funds, where how much fund will be required. At that meeting, it
That
was,
they have already clarified in the.
no, lordship, no proposal has been sent. Lordship, let me clarify that in that meeting, it was held that 27 crores will be required. That was a statement. I have my instruction, lordship. On that meeting, it was stated that around 27 crores will be required.
And that is after the Home and Political Department had consulted with the Assam State Legal Service, Lordship. And now pursuant to that, no proposal has been sent. Once the proposal has been released by the finance, received by the finance department,
Who is going to submit the, who is
Home and
required to
Political-
submit the?
the government, Home and Political Department, Lordship.
Where is the home department?
Lordship here.
Yes,
Lordship, may kindly peruse the, my lord.
what is this business that one department is asking to submit so and another department is sitting and you are not the separate identities, you are the wings of the state.
Lordship, may kindly peruse for a moment, page 124 of the additional affidavit filed by the Legal Service Authority, my lord.
Yeah,
My lord, I have written to the Legal Service Authority 124, my lord.
yeah.
With reference to the subject cited above, I am directed to inform you during the current financial year 2024-25, there is a budget provision of 9 crores under the head of account so and so. In view of the above, you are requested to kindly to submit financial sanction proposal along with prescribed checklist and certificate at the earliest so that department may place the proposal before the departmental financial committee for necessary approval and onward submission of the ceiling proposal to finance department as per procedure. That has not been done, my lord, because of that, my lord.
My instruction has been done already. It has already been sent. In fact, the quantum has now increased from 44 crores. Although it's a very recent affidavit, my verbal instructions today in the morning are that the quantum has now been increased to 55 crores. And the pendency is increasing day by day. And these are all pending claims.
They said they already sent this, whatever you have asked for.
My lord, I have, my lord, received this copy today itself, my lord.
My lord, the budget is, my lord, in the month of March, my lord. There are 9 crores, what they are saying about, my lord, it is a matter of month of March, my lord. Afterward, Lordship passed a specific direction on 5/4/2024 in paragraph 5, Lordship, and there is a clear direction, Lordship. May I read for a moment? Paragraph 5. It appears that there is a lack of coordination between the home as well as the finance department. However, we are expecting that by the next date of hearing with the coordination between the concerned department, the state of Assam shall come with a definite proposal for release.
Mr.
Nothing is there,
Advocates for Finance and Home Department, please don't pass the buck. This department is responsible and this department is responsible. We'll force to, ask the secretaries to come before this court. This is ultimately you are not giving any bounty. This is the victim compensation scheme.
Their own scheme.
As per the statute, you are supposed to provide the fund for that, sir.
So far, my lord, earlier years, my lord, because of, my lord, not having.
Until
ceiling-
Lordship pass a specific direction, my lord, I think they will never come, they will come in piecemeal manner, my lord, passing the time, my lord.
Finance Department will release and compare with the proposal the moment because
That's all, sir. We have asked them
Throwing
to
ball,
supply us and
they are the reason.
you are sitting in the very same building. What is this proposal? You are sending letter to this another department and that department is again writing letters. What is this? Yes, that's right.
We'll direct the chief secretary to file a personal appeal.
My lord,
I think that is, other, that will not come.
lordship may kindly give me a chance to, my lord, take instruction on the letter.
Not at
which is-
all. We have already
My lord,
granted you
let-
many.
let-
That's
times.
given, my lord.
I will take, my lord,
Nothing doing.
lordship may
On
kindly.
the last, on this 5/5/2024, we have
Yep,
5/4/2024, we have noted this. That there is a lack of coordination between home as well as the finance department. And still you are not saying that we have asked them and they have already writing letters to you. And what is this?
No, my lord, state legal service already made clear that as per Bhargava instruction, already sent, my lord. Now they have to take it up on, my lord, simple.
Let us, my lord, take instruction on that, my lord.
File an affidavit of the chief
I'll
secretary.
file an
Chief
affidavit.
secretary.
I'll.
That's all.
Lordship kindly point out.
Each department.
I have received the comments from the home department, my lord. They have given a year-wise breakup on which, my lord, they said in the most of the occasion, my lord, not having the allotment of ceiling, fund could not be released, my lord.
You do it. The petitioner has filed this PIL petition raising a serious question regarding the non-payment of compensation to the victims under the Assam Victim Compensation Scheme 2012. Stop. This court, while considering the issue regarding the disbursement of the compensation to the victims under the scheme of 2012, has passed the following order on 5/4/2024, 5/4/2024. Quote this order of. Full stop. Again, on 20th of May 2024, this court, taking into consideration submissions made on behalf of the Council for the Finance Department, has passed the following order. Full stop. Learned Council appearing for the Assam Legal Services Authority has informed this court that against the demand of rupees 44 crores or around 44 crores, only an amount of 9 crore has been provided under the victim compensation scheme for disbursement of the compensation to the victims. Full stop. Having heard the learned counsel for the finance as well as the home department, we are of the view that despite making observations in the order dated 5/4/2024, there is serious lack of coordination between the home as well as the finance department. In such circumstances, we are forced to direct the chief secretary of the state to file his personal affidavit that why the required money is not being made available for dispersing the compensation to the victims under the Assam Victim Compensation Scheme 2012. The said affidavit will be filed by the next day of hearing, put upon put upon 15th of July, on the day of the opening.
Indicating as to what, indicating
Indicating as to why the money has not been dispersed.
and the steps proposed to be taken to release the amount
And the steps we propose to be taken to release the amount.
at the earliest.
Dr. Sinha, we just point out that 9 crores has not been given to us yet. It's only a budget provision. I'm not sure that is.
But since they are asking for utilization certificate, it means they have provided.
I'll confirm that. I'll also.
Let it confirm.
My lord, may I pray, my lord, instead of 15, my lord, may I pray, my lord, on 16, my lord, because.
Okay, 16.
My lord. Obliged.
Item 18.
Lords, I appear online, my lord, for item number 18, my lord. The respondents have to file their counter, my lord. So far, we have not received any counter to our petition, my lord. Last time it was directed to be filed counter.
Yeah, what do you want?
My lord, in absence of last time when I asked, I insist for the stay of the impugned order passed under GST, demanding GST. Your lordship has told, directed that let the reply be filed. After that, we'll consider the stay order. My lord.
So
But so far,
filed the
they have
reply?
not. No, my lord, they have not filed, my lord.
Yes, why you are not filed?
Lordship, allow us some time to file affidavit.
We have already granted you time on 6/5/2024, a month before.
Lordship. Lordship,
So what?
Lordship, allow us further time to file.
How much further time?
Lordship, 1 week, Lordship.
Now they are insisting on stay.
Lordship, my senior is out of station and he has received
That
instruction.
can't be, you have to file the reply.
Yes, Lordship.
We are granting you last opportunity, otherwise we'll pass an order for this interim order. On 6/5/2024, the Learned counsel for the central government, Mr. Kayal, raised some time to file counter to the writ petition. Full stop. Till date, no reply is filed. Then counsel appearing pursuant for Mr. Kayal, raise further opportunity to file counter to the writ petition. In the interest of justice, a week's time is granted to file counter to the writ petition on behalf of the respondent number 3, failing which the prayer for interim relief, filing counter the writ petition on behalf of the respondent number 3. It is made clear there on the next date of hearing, the prayer for interim relief would be considered without waiting for, considered even if the reply is not filed on behalf of the respondent number 3. It is this writ petition on 18th of June.
Highly obliged.
Deep replacement.
19th of June.
19th of June.
19th of June.
Please.
Item 19.
Lordship, same prayer, Lordship. Kindly adjourn the matter for a day.
Same prayer, there you prayed for the granting further time to file reply.
Lordship,
Here also,
no, Lordship.
Mr. Is there any urgency?
No, my senior is out of station, Lordship.
Just after summer vacation.
Highly obliged.
Item 20.
My lord, I have got the report from all the districts, my lord. From the report, it appears, my lord, in Karimganj district, my lord, altogether 18, my lord, fraud doctors have been found. And in Tinsukia and Dibrugarh, one each, one doctor.
Only.
Only, my lord. They have verified everything, and now this is the report I have got. I would like to file an affidavit, my lord. I got it on Friday only. Let them file the affidavit.
Mr. So-and-so, please some time to file affidavit regarding the action initiated by the respondents to check the menace of coax in the state of Assam. Stop. Based on so-and-so.
Like this.
Summer vacation.
Supplementary list, item 37 for orders.
My lord, this item came up for Lojima on the last Friday. But respondent number 8 has been already appearing. 6 has already submitted their objection. My lord, and then the rest of the other 2 has not appeared as yet.
9 and 10, there is no service report.
No, they have not.
No, dated 6/6/2024, your lordship. The neither answer of notice nor AD card in respect of respondent number 9 and 10 is yet to be received.
So we should await service report
Yes,
or?
your lordship.
Yes, ma'am. We have taken steps, but they are not appearing. But
But
one thing more
Still
in this,
the service is not complete now. On respondent number 9 and 10,
Yes, your
my lord, we have been serving notices many times, but they are not responding. That is.
neither answered notice nor ready and respondent. So will on 6/6/2024, we'll await for 2 more weeks.
Yes, my lord. In the meantime, what is happening actually, there are a lot of other construction works are going on there. And then
Yeah.
respondent number 6, who has been actually replied to us, objecting that they're not having any blockades. But my lord, actually, they are the person who is constructing the walls, basically blocking the bridge, water flow.
You are disputing that.
Yes, my lord, I have already submitted my reply.
You have
So there.
already filed against that. What they are constructing?
They were constructing a wall, my lord. You can see in the page, in the photographs also I have submitted, my lord, in the page number. Yes.
State has filed reply?
Yes, they have,
Lordship,
they responded number, yes.
an affidavit respect of respondent number 5 has been filed, who is a circle officer of Palashpuri Revenue Circle. So that has been filed, your lordships. There it is stated that the reclassification of the land has been granted only as per the existing rules, your lordship.
My lord, that is in page number 29B. You can see in my repeat in the petition, my lord, the PIL petition. It's very clearly and it's depicted. This is it. This is it, no? I can give you some.
Since you have leveled allegation against the respondent number 9 and 10, you have to get the notices served upon them.
Yes, my lord, but then in the meantime, they are already constructing the walls more and more.
Get the notices served, we'll
Yes, my
ask
lord.
them for filing their response, then only we can issue any
Yes, my lord,
instruction.
respondent number 6 has already submitted their reply into this.
What about 9 and 10, madam?
Yes.
You have also made them party and raised allegation that they are also raising
They are also doing it.
transactions illegally.
Yes, my lord, but then in page number 194, my lord, I have given this reply in survey. In that reply.
In response to the, what about the respondent number 9 and 10?
No, they have not submitted yet.
But get the notices served upon them.
My lord, we have taken.
Can you make
steps.
dusty service?
Yes, I know. Yeah, oh, yeah, okay, with that we can do that. That's it.
Yeah, notices issued to the respondent number 9 to 10 has not been served since long. The next consent of the petitioner is directed to make fresh steps for service of notice upon the respondent number 9 and 10 through registered AD as well as the state. The requisites be filed within a period of 10 days. On filing of the same, let notices be issued to the respondent number 9 and 10 returnable on July.
Yes, 24 July. Daily list for hearing, item 21 to 25.
But from the state authority, well, we have got some instruction below. They have prayed for 7 days more time.
Yeah.
They state, the personnel department, they have instructed us to pray for 7 days time for the instruction of the state.
You have to file and joint affidavit on behalf of the APSC as well as the state.
No, APSC, whatever,
APSC has already.
They have already filed, I have
Made
already.
their stand clear.
We have already communicated the APSC stand to the department. Let the stand, the department come, kindly give us 7 days time.
We can clarify that this will not be a precedent.
Yes.
What else is there? The APSC has already taken a stand.
But without the stand of the.
Larger ramification means what larger ramification? If it is not made a precedent,
But,
it's only about 4 or 6 candidates.
But 6 candidates, but in respect of 4, they have said all of them have not cleared the prelims. Whatever it is, we have the stand and the minors copy we have given them.
Single day
Since the
taken
department,
into consideration everything. The question is that in respect of these 6 persons, and we are not granting them much relief, only the appointment and the seniority also in the, only a batch wise seniority and nothing else.
That's all. And prelims is a screening.
Screening.
That is one way of screening. Let's take it that there has been another way of screening of these 6 candidates in this.
Two more layer.
Yes. So they have
Mains
moved
and
on
private
now.
was it.
since Lordship has sought for the.
Can you now say that since you have not cleared class 10, so your graduation is illegal? You can't say that.
This is what the extent of the APSC itself. This is what the extent of the APSC.
If the department is agreeable to that.
Concern appearing from the
Next time.
state, state's last opportunity of a week's time to clarify the extent of the state government by filing an affidavit based on 19, 24,
18. 18th or 19th.
Peaceful about it. 20th.
Item 26.
Your Lordship, I may kindly be permitted to appear in person.
Sure.
Your Lordship, I have prepared an appeal, W8 297 of 2021
This is a matter for hearing, no?
hearing.
Who is appearing for the respondents?
Union.
Who is appearing for the respondents?
Where's Shikal? Shikal is there.
Mr. Kayal is appearing, I think so, in the matter, and today mention is made on his behalf that he is out of station. SC Kayal.
So matter can be postponed on next Thursday, Lordship.
Fix it on 20th.
One more thing, I am retiring in February next year,
You are retiring in
February next year.
February next year.
Yes,
First time is there.
okay.
20th.
Obliged.
Item 31.
Make please, Your Honor.
After respondent Board and University, my lord, some medical emergency of my senior, my lord, kindly matter may be adjourned for the day, my lord. It may come on next Monday, my lord.
Yeah, as your lordship.
And go after summer vacation.
It's otherwise a short issue, my lord.
But about
As your lordship
the
pleases.
summer vacation.
Deeply obliged.
Item 32 and 33.
Sorry, man.
Yes.
Look, this read appeal, these two read appeals are filed against the order passed by the Honorable Single Judge. The basic issue is that the date of birth of the petitioner is 5/3/1956.
Petitioner,
Sorry, my lord, respondent.
the respondent, which respondent?
Uh, respondent number one, my lord.
Respondent number one is Mukund Das and two others.
Two others are, my lord, departments. Serial number one is Mukund Das. He was the petitioner, my lord.
Mukund Das. His
Yes.
date of birth is
5/3/1956.
5/3/1956.
1956.
And
Yes.
what about the other? This Anil Kumar?
His date of birth, I'll just give, my lord. Four, 1956.
4/3.
1956.
1956.
Yes.
March 1990. Yeah.
So both of them retired on 31/3/2016.
Five-three.
5/3.
Yes.
Both of them retired on 31/3/2016.
Fine.
And from 1/4/2016, the ROP rule for revision of pay was implemented in the department, my lord. That your lordship will find. Prior to that, my lord, lordship will kindly come to page 51. It is the order by which he was made to retire.
This is in relation to
Mukund Das.
Mukund Das.
Yes,
The
my lord.
same is the position in Anil
Other
Kumar.
case also, yes, my lord. In pursuance to letter number so and so Sri Mukund Das, GM, Office of CGM General, APGCL, Bijuli Bhavan Guwahati is hereby released from APGCL service today, 31st March 2016, 5 p.m. on attaining the age of superannuation. Thereafter, in the next page, page 52,
Yes.
page 52 is the order by which his entitlements were released after retirement. This is dated 31/3/2016. As the pension rule applicable to the company, corporation, etc. of erstwhile ESCV, the undersigned is pleased to accord sanction the pension, CVP, retirement gratuity, and family pension in respect of Sri so-and-so, who will be retired on 31/3/2016.
Released. That
Yes.
is also, yeah.
So his pension, committed value of pension, retirement gratuity, family pension,
Yes.
these amounts released. Now, my lord, the ROP rule 2017 of APDCL that came with effect from 1/4/2016.
Fine.
That your lordship will find page 53. My lord, here only extract has been given in the writ petition. But I am giving the entire set, entire copy. Now, the issue is with regard to two provisions, my lord. Rule 4, page 54. Rule 4, my lord.
That is application.
Application
revised
of
pay.
the revised pay. For A says, all employees who were in service on 31st March 2016 or who may have been appointed on or after 1st April 2016 shall draw pay in the revised pay structure, pay band with grade pay applicable to the post grades which they have been holding or which they may have been appointed as the case may be. So it provides that all employees who were in service on 31st March 2016 and who come over after 31st March 2016,
Who come over on or after
First
of April.
1st April 2016. So their pay will be revised as per the pay structure given in this ROP rule. Now, serial number B, provided that an employee who was in service on 31st March 2016 may his or her option continue to draw pay in the existing pay band or grade pay pre-revised until the date on which she earns her next or subsequent increment in the existing pay band and grade pay, or until he or she vacates her post or ceases to draw pay in the existing pay band and grade pay. So basically, this rule 4 is with regard to the employees who was there on 31st/3/2016 and who come over after 1/4/2016 or who stays there in the corporation after 1/4/2016, that their pay will be revised in this manner. Now, the other provision is Rule 32.
Yes.
Now it says fitment benefit stroke revision of pensioners stroke family pensioners. So this deal with the persons who retired on or before 31/3/2016, my lord.
1/4/2016.
31/3/2016.
On or before.
Yes. May I read, my lord?
Yes.
The pension, family pension of the existing pensioners, family pensioners, i.e. pre-1/4/2016, pensioners, family pensioners shall be revised with effect from 1/4/2016 in the following procedure. A, the revised basic pension stroke family pension on 1/4/2016 of the pensioners, family pensioners who were drawing pension, family pension on 31/3/2016 shall be fixed by multiplying the existing pension, family pension by a factor of 2.48, and the amount so computed shall be rounded off to the next multiple of 10. The basic pension for all purposes will be with effect from 1/4/2016. B, the revised basic pension in no case shall be lower than 50% of the sum of minimum of the pay in the pay band and the grade pay thereon corresponding to the pre-revised pay scale stroke pay band from which the pensioner retired. Now this is important. This is applicable to those pensioners who retired on or before 31/3/2016 and after completion of 25/33 years of qualifying service as the case may be. the revised pension, family pension in no case shall be more than 70,000. So in my humble submission, Rule 32 deals with a pensioner who retired from service on 31st-3/2016. Admitted factual position is that the respondent number 1, he retired from service on 31/3/2016. After that date, there is no employer-employee relationship. It got severed. Now we granted him pension as per Rule 32. Now he claimed and came up before this honorable court saying that his pay has to be revised with effect from 1/4/2016. And
accordingly pension.
And his pension has to be determined on the basis of that revised pay. So that thing has been allowed by this honorable court in a manner that I'll take your lordships to the relevant provision, the judgment of the honorable single judge, my lord. My lord will kindly come to para 13 of the impugn order, impugn judgment.
Not revision of my pay. 13. Yes.
May I read, my lord? As per sub-rule 1 of Rule 32, the pension stroke family pension of the existing pensioners stroke family pensioners, i.e. pre-1/4/2016 pensioners, family pensioners shall be revised with effect from 1/4/2016 in terms of the procedure laid down by the subclause A and B. One of the issues that has arisen for consideration is whether the procedure laid down in subclause A and oblique or subclause B can be made applicable to the case of the petitioner. It is settled that an employee retires from service in the afternoon of the last day of the month in which he attains the age of superannuation. It is evident from Rule 34 of the Revised Pay Rule 2017 that age of superannuation of an employee of the erstwhile AACB and its successor companies, including AEGCL, is 60 years. By the office order bearing number so-and-so dated 31/3/2016, the petitioner was released from service of the AEGCL at 5 p.m. on 31/3/2016 on attaining the age of superannuation. Since the meaning of pre is previous to before, the procedure laid down in subclause A and B of Rule 32 can be made applicable in respect of the pension of the existing pensioners pre-1/4/2016, meaning thereby the same can be made applicable in respect of those existing pensioners who had already acquired the status of pensioner previous to or before 1/4/2016. By no stretch, pre-1/4/2016 can be equated with 1/4/2016. So basically, the Honorable Single Judge interpreted that term pre-1/4/2016 to be that since he became a retiree on 1/4 or a pensioner on 1/4/2016, although he retired on 31/3/2016, but he becomes a pensioner on 1/4/2016, so both cannot be equated. Now, Lordship will kindly come to para 15. At this stage, it is also apposite to refer to the provisions contained in Rule 4.8 of the Revised Pay Rules 2017, which pertains to application of the revised pay. Rule 4A has laid down that all employees who were in service on 31/3/2016 or who may have been appointed on or after 1/4/2016 shall draw pay in revised pay structure pay band with grade pay applicable to the post grades which they have been holding or to which they may have been appointed, as the case may be. Rule 4A has thus made reference to two categories of employees: all employees who were in service on 31/3/2016 will be eligible to draw pay in the revised pay structure applicable to post grades which they had been holding. Similarly, all the employees who have been appointed on or after 1/4/2016 shall draw in the revised pay structure applicable to the post grades to which they may have been appointed. Para 16. In view of the settled position of law that the employees retire from service in afternoon of the last day of the month in which he attains the age of superannuation, and from the office order dated 31/3/2016, by which the petitioner was released from service on attaining the age of superannuation of 60 years at 5 p.m. on 31/3/2016, there is no iota of doubt that the petitioner was in service on 31/3/2016, and he also retires from service on 31/3/2016. In other words, the petitioner was in service and had also retired from service on 31/3/2016. This court is thus of the view that the petitioner had not acquired the status of pensioner on 31/3/2016, as on that date he was in service and had also retired from service on attaining the age of superannuation at 5 p.m. He had acquired the status of pensioner only from 1/4/2016. This view gets also fortified from the office order bearing number so and so, which recorded that the petitioner retired on 31/3/2016, and the petitioner was sanctioned pension at the rate of 24,660 per month with effect from 1/4/2016. The provision of Rule 32(1) speaks about existing pensioners who acquired the status of pensioner pre-1/4/2016. That is, previous to or before 1/4/2016. And such status can be acquired only on or before 31/3/2016. Now, finally, what has been concluded by the Honorable Single Judge, Lordship will find para 20, page 103.
Yeah.
From a conjoined reading of the provisions of the revised pay rule 2017, more particularly Rule 1, Rule 2, Rule 4A, Rule 32(1)A and B together, this court is of the unhesitant view that the petitioner who was in service on 31/3/2016 and who retired from service on reaching the age of superannuation also on 31/3/2016 cannot be categorized and bracketed in the category of existing pensioner on 31/3/2016, as he acquired the status of pensioner only on and from 1/4/2016. In such view of the matter, the benefits under the revised pay rule 2017 cannot be worked out by resorting to Rule 32(1)A(B) of the revised pay rule 2017, but his entitlement are to be worked out in terms of the provisions laid down in Rule 4A of the revised pay rule 2017. Rule 4A has made the revised pay structure pay band with grade pay applicable to an employee who was in service on 31/3/2016, and the petitioner falls in that category of employees. Therefore, this court is of the view that the respondent authorities shall have to work out the entitlements of the petitioner as pensioner under different heads like pension, commuted value of pension, death cum retirement gratuity, leave encashment benefit, etc. And if after such exercise, the petitioner is found entitled for an enhanced amount, that what has been worked out by the office order number so and so, or by an exercise by resorting to Rule 32(1)A(B) of the revised pay rule 2017, the same should be disbursed to the petitioner in an expeditious manner. It is observed that the entire exercise shall be undertaken and completed within 6 weeks from the date of submission as a certified copy of the order by the petitioner to the office of respondent number 2. This is the conclusion derived by the Honorable Single Judge. Prior to that, I would like to take your lordships to the another communication issued by the accountant general, because same ROP rule was implemented in respect of state of Assam also. So when the representation of the respondent number one came to us, then we wrote letter to the AG office that what have you done in the government of Assam? Then AG office's response, I'll just take your lordships. Page 63. Fixation of pension and other benefits as per the provisions of pay rules 2017. In inviting a reference to your letter number so-and-so dated so-and-so on the subject cited above, I am to state that your letter number so-and-so does not appear to have been received in this office, the earlier one. Moreover, with reference to the clarification sought by you in your letter under reference, I am to state that the fixation of pension and other benefits in respect of the employees of the government of Assam who retired on 31/3/2016 are being settled with reference to the pay admissible to them as on 31/3/2016 under the ROP rule 2010. So in respect of state of Assam, my lord, the employees of the state of Assam, the employees who retired on 31/3/2016, their pension were revised as per the ROP rule 2010, the previous one, my lord. And the query that we asked to AG, in whose response, my lord, this letter was issued, that query lordship will find page 62. Our letter.
Yeah.
Sri Das has claimed by his application that since he was in service on 31/3/2016, hence his pension should be fixed as per revision of pay rule 2017.
Yes.
In my humble submission, my lord, the Honorable Single Judge, my lord, while appreciating Rule 32, my lord, gave credence on this term, i.e. pre-1/4/2016, to come to a conclusion that although he retired on 31/3/2016, and he becomes a pensioner on 1/4/2016, and he doesn't fall under this pre-1/4/2016 term, quote unquote. So Rule 32 will not be applicable in his case. So we'll have to revise his pay as per Rule 4, A and B, and thereafter we'll have to give him pension, my lord. In my humble submission, my lord, this conclusion derived by the Honorable Single Judge is absolutely erroneous, because Clause B of Rule 32 itself provides that this is applicable to those pensioners who retired on or before 31/3/2016 and after completion of so-and-so. So there is no embargo or, my lord, ambiguity in the rule that a person who retires on 31/3/2016, his case will be considered as per 32 and his entitlements will be decided. Once he retires on 31/3, the employer-employee relationship. My lord, an identical matter came up before the Honorable Apex Court in 2008-14 SCC 699. 2008-14 SCC 699. List of books এখন দিছিল। এখানে দিয়ে দেবে। There is a division bench judgment of Delhi High Court also on the same issue, my lord. That's why I referred to the date of birth. Because what the Honorable Apex Court has said, as per FR 56, although you retired on your date of birth is, my lord, 5/3/1956. You were supposed to retire on 5/3/1960, my lord, 2016. But this period you got excess. And for that purpose, you will not get benefit of the, my lord, I have this.
This is the Delhi High Court judge.
A Delhi High Court judgment, my lord, I have given. And Supreme Court judgment 2008-14 SCC 699, my lord.
This Union of the KG George.
Yes, my lord.
This is a High Court of Kerala.
Yes. It came before the Honorable Apex Court from High Court of Kerala, my lord. And,
okay, yeah.
And I have given the learned, my lord, Kerala High Court order also. Why I have given the Kerala High Court order? Because that was reversed by the Honorable Apex Court. The reasons. Yes. The Kerala High Court's order was reversed in 2008-14 SCC 699. Why I have given, my lord? The reasons given by the learned single judge here are identical to the reasons given by the Kerala High Court, which was reversed. It's a two-page
2008-14 SCC
699.
2008
8-14 SCC 699.
Okay, you are referring to this Kerala High Court judgment first?
No, my lord, I'll refer to the Supreme Court judgment first, then Delhi High Court, then Kerala High Court. It's a very small judgment, my lord, only 2 pages, my lord, but substance has been said. The respondents were working in the telecommunication department on the post of senior section supervisor and retired on so-and-so respectively. In view of the provisions of FR 56, they were met to retire with effect from the afternoon of 31/12/1995. The report of the 5th Central Pay Commission came into force with effect from 1/1/1996. Clause 3(1) of the 5th Central Pay Commission report states that the revised provisions shall apply to government servants who retire/die in harness on or after 1996. The grievance of the respondents raised before the High Court was that they should be allowed to recon their pensionary benefits on the basis of the 5th Central Pay Commission report with effect from 1/1/1996. The division bench of the High Court was of the view that since they were made to retire with effect from 31/12/1995 till the midnight of 31/12/1995, they were in service and therefore entitled to retirement benefits from 1/1/1996. We are unable to countenance with the decision of the tribunal and the High Court. As already noticed, they were retired with effect from 16/12/1995 and 3/12/1995 respectively. But because of the provisions of FR 56, they were allowed to retire on the last day of the month, the grace period of which was granted to them for the purpose of pay and allowances only. Legally, they were retired on 16/12/1995 and 3/12/1995 respectively. And therefore, by no stretch of imagination can it be held that their pensionary benefits can be reckoned from 1/1/1996. The relationship of the employer and employee terminated in the afternoon of 16/12/1995 and 3/12/1995 respectively. In view thereof, the order of the tribunal and High Court was accordingly set aside, and these 2 appeals are allowed with no order to cost. So what the Honorable Apex Court has held, that this is the grace period. You will not be entitled for revision of pay by virtue of the grace period.
Claim to continue.
Yes.
Things will be clear if your lordships kindly consider the division bench order of the Kerala High Court, my lord.
First, you are referring to Delhi High Court or Kerala? High Court?
I'll take, my lord, since it's a continuation, it will be, my lord, helpful for me.
Come. Yes.
Yes, my lord. Where the respondents who were in service till December 31st, 1995, entitled to the payment of retirement benefits at the rates as prevalent on that day or at the rates as revised with effect from January 1, 1996. The tribunal has upheld the claim of the respondent number 1 and 2. It has taken the view that the two officials had become pensioner on January 1, 1996 and were thus entitled to the benefits of revision. The Union of India, etc. challenged the order as the tribunal urged. First, the facts may be noticed. The two respondents were working in the telecommunication department on the post of senior section supervisor and section supervisor respectively. They had continued in service till December 31st, 1995. They were paid pension with effect from January 1, 1996. Fifth Pay Commission recommended the revision of pension and other retirement benefits. In pursuance to those recommendations, the Government of India issued two separate orders dated on October 27, 1997. The orders regulated the grant of pension, etc. to the central government employees who were governed by the provisions of the Central Civil Service Pension Rules 1972. The method of fixation of emoluments, pension, gratuity, etc. was laid down. The two respondents were not given the benefit of revision of pension, etc. on the ground that they retired on December 31st, 1995. The orders provided the benefits only to those who retired on January 1, 1996. Consequently, they approached the Central Administrative Tribunal claiming that their pension and other retirement benefits were to be calculated in accordance with the two circulars issued by the government on October 27, 1997. The department contested the claim. It was pleaded that the benefit was only admissible to the person who had retired on or after January 1, 1996. The two respondents had actually retired on December 31st, 1995. Thus, the department claimed that they may not be entitled to the benefits. The matter was examined by the tribunal. It was found that the officers had continued in service till 31st December 1995. They had become pensioner on January 1, 1996. Thus, they were entitled to the benefit of revision of pension, etc. Consequently, their pension was allowed, petition was allowed. A copy of the order passed by the tribunal is Exhibit P3. Agreed by this order, the department has filed the present writ petition. Now the reasons given, my lord. Para 16.
Yes.
What is the position in the present case? The respondent number 1 and 2 had admittedly drawn full salary for the month of December 1995. They were paid full wages for the last day of the month, which December 31st, 1995. In fact, as well as in law, they were in service of the department till the midnight of December 31st, 1995. It is only when the clock ticks 12 midnight that the relationship of employer-employee ceases and the status of pensioner commences. Thus, from January 1, 1996, the two respondents had become pensioners. The date on which the right to claim pension accrues is deemed to be the last working day of the employee. On this basis, the benefit of circular dated so-and-so was clearly available to the respondents. Now, para 19, Milo. We are unable to accept this contention. The two officials had actually continued in service till the midnight, December 31st, 1995. It is only from 1st January 1996 that they had ceased to be in service and acquired the status of pensioner. Resultantly, their claim to pension had to be determined at the rate prevalent on that date. This is precisely what the tribunal has given them. The case is no way different from Banerjee. In both cases, the pay has been paid till December 31st. So finally, para 21. Writ petition dismissed. Now, Delhi High Court judgment, my lord.
Yes.
2018 SCC Online Delhi 12191. Union of India and others versus GC Yadav. Para 2, my lord. The Union of India has preferred the present writ petition to assail the order dated so-and-so passed by the Central Administrative Tribunal Principal Bench, New Delhi, in OA number so-and-so. By the impugn order, the tribunal allowed the original application preferred by the respondents and held that the respondent applicant is deemed to have retired from service on 1/1/2016. Consequently, the tribunal held that he was entitled to get the pensionary benefit in accordance with the 7th Central Pay Commission recommendation. The office memorandum dated 3/1/2017 issued by the petitioner asserting that the respondents had retired on 31/12/2015 was quashed and set aside, and the petitioner was directed to fix the retirement benefits of the respondent in accordance with the 7th Central Pay Commission, which was implemented by OM dated 4/8/2016 in respect of the pensioners retiring on or after 1/1/2016. Now, para 3. The date of birth of the respondent is 1/1/1956. Considering that the age of retirement superannuation is 60 years, he attained the said age on 31/12/2015. As per the petitioner, the subject of retirement is governed by FR 56 in Chapter 9 of FRSR. The said chapter deals with retirement. FR 56, insofar as it is relevant, reads as follows. FR 56A, except as otherwise provided in this rule, every government servant shall retire from service on the afternoon of the last day of the month in which he attains the age of 60 years. Provided that a government servant whose date of birth is the first day of the month shall retire from service on the afternoon of the last day of the preceding month on attaining the age of 60 years. So first one is with regard to the proviso is with regard to the first day of a month, then he'll retire the last day of the preceding month. And if his date of birth is in between, then he'll be in the last day of the particular month. Now, under these facts, what has been held by the Delhi High Court, para 10, your lordship will kindly take.
Yes.
Having heard the learned counsel for the petitioner so-and-so peruse the record and the relevant rules, and having considered the submissions advanced by the respondents and the decisions relied upon by him, we are of the considered view that the respondents could not be considered to have superannuated retired on 1/1/2016, and he could not be treated as post-2016 pensioner. We are of the view that the impugn order passed by the tribunal cannot be sustained and is liable to be set aside. Firstly, we may observe that since the date of birth of the respondent is 1/1/1956, he attains the age of 60 years, i.e. the age of superannuation on 31/12/2015. The respondent appears to be reeling under the impression that he attained the age of 60 years only on 1/1/2016, which is not correct. On 1/1/2016, the respondent entered into the 61st year of his life, having completed his 60 years on 31/12/2015. The issue of retirement in respect of central government servant is covered by FR 56. We have already quoted the relevant extract from the said rule. The first proviso to FR 56A is clearly attracted in the facts of the present case, since the date of birth of the respondents falls on the first day of the month, i.e. 1/1/1956. Consequently, by virtue of the first proviso to Rule 56A, the respondent retired from service on the afternoon of the last day of the preceding month on attaining the age of 60 years. In the case of the respondents, that was the afternoon of 31/12/2015, even if the expression afternoon is construed broadly, it could only extend to the midnight of 31/12/2015, and same would not cross the said deadline. As at the beginning of 1/1/2016, i.e. from 0 hours of 1/1/2016, the respondent ceases to be a serving employee, having superannuated on 31/12/2015. At no point of time on 1/1/2016, the respondents could be said to be in active service. At no point of time in the year 2016, the respondent worked in the post. The pay or emoluments of which were fixed on the basis of the recommendations of the 7th Central Pay Commission. He was not entitled to receive any pay on or from 1/1/2016. Thus, the question of revision of his pay premised on the recommendation of the 7th Central Pay Commission did not arise. The said recommendation became effective from 1/1/2016 in respect of employees who were in service on 1/1/2016, which respondent was not. We agree with the submission of Mr. Bharadwaj that the tribunal has erred in placing reliance on the judgment in S. Banerjee in the facts of the present case. The material difference in the facts of S. Banerjee and the facts of the present case is that S. Banerjee, the petitioner S. Banerjee sought voluntary retirement from a particular date with effect from 1/1/1986. It is open to the employee seeking voluntary retirement to choose the date of his voluntary retirement, unlike the case of superannuating government servant whose date of retirement is determined by FR 56. The Supreme Court took note of the fact in S. Banerjee that the petitioner was permitted to voluntarily retire from service from the afternoon of 1 January 1986. Thus, it could not be said that so-and-so has retired at any point of time on 31/12/1985. He continued to remain in service till forenoon of 1st January 1986. Before his retirement on the forenoon of, yes.
The sum and substance.
Then para 17, 20 and 22. Mila 3 paragraphs I'll just place before you. Lordship.
Will come.
Regarding item 37, your lordship has fixed it on 24th of July, your lordship. But if I have some personal inconvenience, I won't be available last part of the month, your lordship may kindly fix it on 1st or 2nd of August, your lordship.
Will you inform that other
Yes,
side?
I'll inform, yes, your lordship.
You-
One of the respondents I have informed. I'll inform the petitioner, your lordship.
Petitioner, when you want?
On 1st or 2nd of August, your lordship. I won't be available, that's fine.
इसको देख लेना, 1st of August. Yes, Lordship. Inform the council.
Yes,
for
your
that.
lordship, I will do. Deeply obliged, your lordship.
So you are referring to para 17 of the. Delhi High
Para
Court.
17, yes, my lord. Para 17, my lord. As noticed herein above, in the present case, by virtue of first proviso to Rule 56A of the FR, the respondent retired on afternoon of 31/12/2015. He did not see the light of the day as the serving government servant on 1/1/2016. Thus, the decision of S. Banerjee was clearly not attracted in the present facts of the case.
Yes.
Then para 20, my lord. Firstly, in our view, the said decision in P. I am Perumal was rendered in a materially different fact situation. The issue determined by the court was not with regard to the date of retirement stroke superannuation. In fact, on that aspect, the finding returned by the Madras High Court High Court goes contrary to the submission of the respondent that he retired on 1/1/2016 and not on 31/12/2015. Secondly, the relief was granted to the petitioner by the Madras High Court since the increment which fell due on 1/7/2013 has been earned by the petitioner by working for full year, i.e. 1/7/2012 to 36/2013. The same cannot be said about the revision of pay upon implementation of the Central Pay Commission recommendation. Thirdly, the decision of Madras High Court was only persuasive value, and in the facts of the present case, we don't think that ratio of the said decision is obstructed. Now, para 22. For the above, for all the aforesaid reason, we allow the present writ petition. Set aside the impugn order passed by the tribunal, we hold that the respondent was not entitled to pay revision with effect from 1/1/2016 under the 7th Central Pay Commission recommendation, since he was superannuated on 31/12/2015, and he was not entitled to fixation of his pension on the premise that he retired from service on 1/1/2016.
Yeah.
So this was the conclusion derived. Look, in my humble submission, the rules are absolutely clear, ROP rules. Even although I have referred to Rule 4 and Rule 32, Rule 5 also of the ROP rule, Lordship will kindly have, it's very specifically it said regarding the date of effect. Rule 5, procedure for fixation of initial pay in revised pay structure. The initial pay of an employee of the successor companies who is in service on 31st March 2016 and entitled under this rule to draw pay in the revised pay structure shall, unless the successor company by special order directs otherwise in a special case, be fixed on the date she becomes so entitled in respect of a post or post referred to in sub-rule B below in the following manner. There is an appendix, my lord, wherein, my lord, revised pay structure has been given. So who is in service as on 31st March 2016, they will only be entitled. And so far as Rule 32 also, it is explicitly clear. So the interpretation given by the Honorable Single Judge only quote unquote taking into consideration that pre-2016, that since he became a pensioner on 1/4/2016, so he will not be bracketed in that term pre-2016, my lord, in my respectful submission is absolutely erroneous, my lord. And another aspect I would like to point out, while this writ appeal was admitted, my lord, there was an order passed by this honorable court, wherein the honorable court has refused to pass a stay order. But
undertaking
they'll give an undertaking, and in pursuance to that, my lord, I'll just place before your lordships. So we took undertaking the financial implication per person. My lord, why I'm referring to this to your lordships? Lordship, first, lordship will find this undertaking that the person concerned has given.
Shall be liable to a reimbursement fee.
Yes, my lord.
Reimbursement.
And second one, my lord will find. This is how we have paid after by following the honorable single judge's order. So, my lord, the financial implication comes to around 38,29,929 approximately.
In respect of?
This Mukuddas.
Only one.
There are, my lord, that's why I have given the minutes of a meeting. My lord, there are total 131 employees of similarly situated. I'll just read this minutes, my lord. The matter regarding providing benefit of revised pay scale as per ROP Rule 2017 to the employees who retired on 31/3/2016 of APDCL, AEGCL, APDCL was taken up for a cumulative decision. The JCC noted that the total financial involvement for providing such benefit to total 131 number of pensioners will be around 21.1 crore, out of which 9 number of pensioners, 4 pensioners from APGCL, 5 pensioners from AEGCL were already granted the said benefit as per the court order in WBC so and so. A decision has been taken to extend the benefit to the remaining pensioners, and financial involvement for the same will be around 18 crore. As it has been informed by AGCL Pension Trust, Fight Communication dated so and so, that the cash flow of ACB Pension Trust is not sufficient to meet such huge financial burden. And any deficit, it has to depend on the Government of Assam budgetary support. Hence, it is decided to disburse the entitlement in installment basis. Further, the JCC also noted that an appeal has been preferred before the Honorable Division Bench of the High Court, bearing WA number so and so against the order dated so and so passed in so and so. In the said appeal, the Honorable High Court, by order dated so and so, was pleased to direct that the respondent shall furnish an undertaking to the effect, in the case that in success of his appeal, he shall reimburse the excess amount, if any, paid to him on account of the impugned order passed by the learned single judge. In the light of the said order, the committee decided that an undertaking should be taken from all the pensioners that the entitlement paid should be subject to the outcome of writ appeal so and so. In the case of success of the appeal, the pensioners shall reimburse the excess amount paid to him, if any. On receiving application and undertaking from the respective pensioners, the revised monthly pension, considering the rule followed by the Government of Assam on restoration of committed pension, will be paid within 2 months of such application. However, arrear benefit will be paid in 5 installments in the span of 2 years. Now, my lord, after the order of the learned single judge and division bench ordered that they will be entitled and they will be liable to reimbursement, my lord, several writ petitions are filed before this honorable court, before the single judge. And on the first day itself, my lord, taking into consideration the single judge's order as well as the order passed by this honorable court, those writ petitions are allowed. And we are facing this issue at present of in future we'll face almost 131 employees, my lord. And financial implication is also not an issue, my lord. The issue is whether the respondent number 1 is legally entitled or not. In my humble submission, going by the ratio laid down by the Honorable Apex Court and the Delhi High Court, and considering the FR 56, my lord, the respondent number 1 is not entitled, my lord. That is my respectful submission before. And one more thing, my lord, the rules from the very beginning, rule 4.5.32 was explicitly clear. There is no room for any interpretation, my lord. But the learned single judge went to interpret in a manner which is not in a manner, my lord, the purpose for which the rule was incorporated. Rule was introduced to give pay revision with effect from 1/4/2016. That is the purpose of the rule. So the conclusion derived by the learned single judge defeats the purpose of the whole purpose of the rule, my lord. That is my humble submission, my lord. Deeply obliged for the patient hearing.
My lord, I'll make a very unusual submission. My lord, I would like to go through these 2 judgments very carefully. Privacy, my lord, actually these are distinguishable. But since, my lord, the stakes are very high.
These 2 judgments, you mean to say the Delhi High Court and Supreme Court?
Yes.
Delhi High Court and Supreme
Yes, my lord, our claim is slightly different. Our case is we are not seeking pension from 31/12. We say our last pay should be revised in terms of 4A. And accordingly, my pension should be computed. That is our case. Here in this case, prima facie, I find, my lord, the Kerala High Court judgment, the 2 respondents were not given the benefit of revision of pension, etc., on the ground that they had retired on 31/12/95. The order provided benefit only to those who had retired on 1st January. So therefore, my lord, since stakes are really high, so I would just pray for some time, my lord. I would like to go through it and make my submissions. Prima facie, my lord, I find the facts are different in both the cases. Moreover, Here, my lord, rule 32 is on a different tangent altogether. Had it been our case, my lord, we are not seeking any revision of pay.
No, you are seeking these.
My pay as on 31/12 to the 2016 should be revised.
Ultimately, the question is.
Yes.
Whether you'll be treated as a pensioner from 1/4/2016 or the 31st of March 2016.
No, my lord, that is their contention. Our case is very simple.
Coupled with the fact, this
I-
clause 32(1)(b.
Yes,
It specifically says the revised basic pension in no case shall be lower than so and so, so and so.
yes,
Scale of pay from this is applicable to those pensioners who retired on or before 31/3/2016.
yes.
So after your retirement, you
No,
on
first,
30
no, first of all, my lord, unlike 31(1), there is no similar provision in those here. No, if your lordship will kindly come to
Yeah.
32(1).
Yeah,
Pension, family pension of existing pensioner, family pensioner. That is pre-1/4/2016 shall be revised with effect from 1/4/16. We are not covered by this clause. We are not pre-1/4/16 pensioner. My lord, only thing is, my lord, but for these two judgments, otherwise I was prepared, my lord. Since two judgments had some bearing on the adjudication of the issues, I'll ideally pray for 2-3 days time, my lord. Lordships can have it on next week, on,
20th,
yes.
20th.
I'd like to go through a little bit more in detail, my lord. And my lord, with all greatest of respect, my lord, the observation in the judgment that after my actual date of retirement, the horse FR 56, there is no master servant relationship.
That we have already discussed.
Oh.
That may not be, yeah, whatever it may be, it's ultimately.
Ah. Therefore, my lord, I think, my lord, I'll have to find out some judgment on implication of FR 56 also. I thought, my lord, it's a very open and shut case. Now, my learned friend has really done some good homework. Therefore, my lord, we'll have to burn some more midnight oil.
ये रखना है ना लिखिए the arguments of Mr. Das heard Mr. Das at length. Mr. Chaudhary, please 2 days some time to prepare the matter based on so and so 20th.
Deeply obliged. Deeply obliged.
Item 35 and 36.
Okay. My lord, for last about 1 year, a public road construction has been stalled because of this matter. So, my lord, we'd like to argue for final disposal.
It is for the final disposal.
Yes.
It is listed in hearing category only.
But I'm told that your lordship is rising at 3:15 for.
It will take some time.
No, I'll try to be as brief as possible, but without.
What about the other side?
I should not be taking long. It's not a very long matter, my lord. It's very short compass. It depends upon my learned friend how much he takes.
No, I'll just.
What happened?
He says sometimes man proposes, God disposes. So in. So when we refer my lord.
See, if you can 25th. We can have it on 25th.
Yes, yes.
As first item.
First?
First item.
First item of hearing.
Yes, yes.
First item. First item of matters fixed for hearing.
इस one case होता है सुना एक case में तुम्हें तो मैंने होता है I'm sorry.
No, my,
When we
my,
hear.
no, no, yes, yes. So, my friend says that you should know the code first before you know the facts.
No. What I was telling him, some cases are jinxed, man. Some cases sometimes they do not proceed for some reason or the other.
Okay. We thought you are fixing some place of meeting for the evening.
No.